Well, hello everyone, and welcome to One Civil Law. And in an item of good news for the rule of law, the Trump administration has returned the man who was wrongfully deported back to Guatemala, back to the United States for further proceedings. This is a case that I've previously commented on quite vociferously. This is a case where I read the U.S. Supreme Court case relating to this guy, and I chanted, "Bring him back, bring him back." And then there are people on chat were like, "No, you misread it. That's not what the court said. They didn't say bring him back." Well, I think that is what the court said. And in any event, he has been brought back. So the Trump administration has done what the Supreme Court commanded, or at least strongly suggested, either way. So he is back at the United States for further proceedings. So this is very good for the rule of law, and I'm very happy about this situation. So we're going to discuss this. From the headline, Trump administration has returned the Guatemalan man to the United States after judge had said he was wrongfully deported. Not so much just the judge, incidentally, but, the U.S. Supreme Court said that. The Trump administration had returned the Guatemalan man to the United States after the judge, again, not so much the judge as, the United States Supreme Court, had determined that he was wrongfully deported without due process. His legal team told CBS News the man, who had gone by OCG in court proceedings, landed in the United States today and made contact with his lawyers after he landed, according to one of his attorneys. So his attorneys seem like pretty confident that he's back because, they met with him and stuff. Last month, the Trump administration said in court filings it was working to return the man after the U.S. District Judge, and again, not so much the District Judge as the U.S. Supreme Court, said he must be returned. This was a first high-profile case, of whether it's the first is debatable, but whatever, in which the Trump administration has brought back someone who was removed from the country after a judge ordered the return. Again, not so much the judge as, again, the U.S. Supreme Court, but whatever. His attorney said that he expects the man will be taken into government custody as he seeks protection from persecution. The attorneys argued the man had no criminal history and sought asylum in the United States after multiple violent attacks in his native country, Guatemala. Importantly for our analysis, he had entered the United States illegally and was deported. After making it back to the United States again last year, he presented himself to Border Patrol for asylum. The immigration judge found that he'd face serious harm if he was sent back to Guatemala and ordered withholding of removal that barred deportation back to his home country. So there was a deportation proceeding against the man. There was a valid deportation order against the man, but there was a withholding of removal to his home country. So if the United States could have gotten agreement from some other country to deport the individual back to that country, that would have probably been fine because there had been a deportation order. And so he could have been deported somewhere else, but he couldn't have been deported to Guatemala. And they deported him to Guatemala, the very thing they weren't allowed to do by the order. So the Trump administration defied the order because they deported him back to the very place they weren't allowed to send him. Yeah, and that was illegal. And now he's back in the United States. So we can, deal with that accordingly. 2 days after the immigration judge's decision, he was placed on a bus to remove without process to Mexico, where attorneys said he was previously removed, held for ransom. He submitted evidence of his hearings in Mexico. And as a result, the judge said he could not be removed to a country other than Guatemala without additional due process. So then they said, okay, the initial order said you can't deport him to Guatemala, but you can deport him somewhere else. And then another judge said, okay, you can't even deport him to any other country. So not so much with deporting him anywhere until, further proceedings. After he was sent to Mexico, Mexican authorities removed him to Guatemala, which hid him until his return. So, so that all happened. And blah, 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 blah. So basically, he's back in the United States pending further proceedings. So that's sort of where that ends. And, again, I'll sort of state what I've said before. If he's here illegally, I have no problem deporting him. That's fine. But there are rules around this. There are laws around this. And there's processes relating to that. And you have to go through certain processes. And then when judges make orders, those orders have to be honored and respected. And they have to be followed. It's part of our checks and balances in our system. And so, illegal immigrants, deport them all. It's fine by me. But there are processes you have to go through. And then when a judge makes findings, those findings have to be respected until they're overturned. Those findings might have been in error. Those findings might have been incorrect. He might be a member of a gang or something else, but you go and change the order. You go and challenge the order. You get it changed, and then you can deport him. So you just have to follow the rules. And the Trump administration didn't follow the rules. And so, that's a problem. So anyways, he's back in the United States, wherein he could potentially get a deportation order again very quickly, which would be fine by me. Right? It's like, I have no problem with deporting the guy. I have no problem with reevaluating his status. I have no problem with the Trump administration going back to court and getting his status changed, getting the order changed if his status needs to be changed due to changes in Guatemala or due to other factors. If there's things that need to change, if he's not entitled to protection for any number of reasons, then go to court and get that changed. And in an immigration proceeding, that can be fairly cursory. So if they go through a lawful process and that process is cursory and then they redeport him, that's fine by me, because then they will follow the rules. And that's all I ever wanted in the first place. So, if an immigration judge takes a look at this and changes the order or whatever, that's perfectly fine. I just want the rules to be followed, man. That's all I want. And so I'm happy that he's back and the rule of law protects everybody. He may be a scumbag. He may be a gang member. He may be anything. I don't know. But the rules are there to protect everybody. So, and the government is trying to do something. And when the government does something, that's, what the Constitution is there for, to prevent them from doing things. So yeah, all that good stuff. So that's the end of that discussion. So, yeah. So I don't know that I really have much more to say than that, but it is what it is. And hopefully, to the extent they've been ordered to return other people, they'll return other people. That'd be great too. So yeah. Okay. Well, that's pretty much the end of our discussion. I don't really have anything more to say about it. Really just deport all the illegal immigrants. Go through the process as cursory as it is. Kick them out of the United States. They came here illegally. That's against the rule of law. Kick them out lawfully. That's the rule of law. Court orders should be respected. That's the rule of law. And that's the end of that discussion. What are my thoughts on children who are brought here illegally? You kind of answered the question you answered it from my point of view in your question. If they were brought here illegally, they were brought here illegally. And that is not respecting the rule of law. So deport them is what I say. I don't care. They were brought here. Yeah, the answer is built into the question. If the children are brought here illegally, deport them because they were brought here illegally. I don't care. Children don't get to violate the rule of law either. That is not how that works. It's fine by me. Anything else? I don't see anything else in chat right now, so I guess we'll just end the stream. Okay. Well, thank you for dropping by. Court tomorrow is canceled, as I'm sure you know. The defense team has apparently indicated they're looking to rest around Tuesday. Sounds plausible. So if they rest, give or take Tuesday, then, depending on other factors, maybe there's a jury decision by the end of next week in the Karen Reed case. So this case is coming rapidly to a conclusion, and then we'll see where we are in terms of that. So will be interesting. Is it still legal to ask for asylum at the border, at a border checkpoint? Sure. Of course it is. Yeah, it's still legal to ask for asylum at a border checkpoint. Always has been. How do U.S. laws apply to non-persons or illegal persons? The same way, comparably, not necessarily the same way, but a comparable way to a person who violates a crime, I suppose, of any kind. A person who violates any sort of law. That there's due process of law, regardless of what law you're breaking. The nature of that due process can change depending on what exactly we're doing. Of course, deportation is not considered a criminal proceeding unto itself. So you're not entitled to criminal protection, and the protections for illegal for standard deportation are very, very low. But to some degree, it's at least comparable to what happens when you violate any law. There's some sort of due process of some variety, and then adjudication and all the rest of it. Due process, of course, is literally the process that is due. What process are you due? And that process can depend a lot on what we're talking about. So what process is required? But there's something. Not for the least of reasons, of course, that we have to determine that the person is in fact an illegal immigrant. And also what country they're from, so we know where to deport them. So there has to be some kind of process because we have to be able to make that determination. And if the administration says it's true, but you don't think it's true, then there has to be some way to challenge it. So there has to be some process for if they make a mistake. You shouldn't get it going out. Well, part of the problem is you're presupposing that they're illegal, which is an accusation, right? So it's like, how, even if you think that illegals should get no process, even if you think that, how do you know they're illegal? Right? How do you know they're illegal? That's a problem. Surely it just can't be if the administration just says it. Like they couldn't possibly make a mistake. They couldn't possibly make a mistake and say someone is illegal when they're not. So even if you think illegal immigrants should get no process, how do you determine that they're illegal without process? So you kind of and around you go. It shouldn't be hard. I didn't say it should be hard. Again, the due process can be fairly minimal. I didn't say it should be difficult. It can be fairly cursory, but it has to be something so that we know it's true. There has to be some kind of process so we can determine that they are in fact illegal. Otherwise, what do we do? Right? I mean, the only alternative is that there's no process, which means that the administration would just declare it to be true. And what if they make a mistake? The government can't make a mistake. They make mistakes. So so I didn't say it should be hard. I said that there has to be a process of some kind. It's because you have to at least determine they're illegal in order to make the determination they shouldn't be entitled to due process, which means you have to give them due process to make the determination. It bootstraps itself. Show your birth certificate. Well, that's still a process, isn't it? Right? If that's the process, that is still a process, right? If the process is literally, okay, show us a birth certificate, right? Suppose they arrest me. Suppose they arrest me and they say, we think Uncivil is an illegal alien. We'd like to deport him. If the process literally is show us a birth certificate, that is still process. I'm entitled to that process. Then, by your own reckoning, I'm entitled to that process. I'm entitled to the process of being able to present them a birth certificate. That is process that I'm now entitled to. So you are now conceding I'm entitled to due process, even if it's literally show us a birth certificate. What if I don't have one? What if I don't have one at my house? I have to go get it. I have to go, to my original state and get one because I don't have one. I have to go get one. I have to go get one sent to me. So I have to go get it. All right. So it's like, yeah, there has to be something. There should be some process, right? Your papers showing you're here legally should be easy. No, not necessarily. There's no particular requirement that anyone is required to have any particular papers. There's no particular requirement unto itself that I'm required to have a ID of any kind as a US citizen. I'm not legally required to have ID of any description. There is no law that requires me to have an ID, generally speaking. There's no law that requires me to have a copy of my birth certificate readily available. So what do? You got to have a process to deal with it, which means I'm entitled to the process. There's no requirement that you have papers. What are you talking about? Do you think every American should be required to have papers on them at all times? Do you think every American should be required to have papers like in their house readily available? Do you think we should pass a law that every US citizen must have papers and maybe have those papers on them all the time? That's a very different country than the one we currently have. You think you should be required to have like your birth certificate on you at all times? I don't know, man. Okay, if that's what you think we should do, then okay. Let's pass the everyone must have their birth certificate on all times act. Let's pass that law. Good luck getting support for that. I think you're going to have some problem with some of the right-wing people. I think you're going to have some problems with the every American needs to have a birth certificate on all times act with some of the right-wing people. I don't think some people on the right are going to like that plan. You're required to have an ID if you're driving? Yes, but listen to more carefully what I said. I said generally speaking. Now you're giving a specific, right? I said, no, you as an American are not required to have an ID on you, generally speaking. There is no law that requires you to have a license or an ID, generally speaking. Then you say, well, they do if they're driving. Yes, that's a specific example. That's a specific. In general, you're not required to do it. If you want to do something specific, like drive, then yes, now you are required to have an ID. But now you're trying to do something specific. There's no law that requires you to have an ID just for being an American. There's no law that requires you to have an ID just to like live in the United States. There's no law that requires you to have identification papers just to be living in the world. That law does not exist. There's no law that requires you to have ID on your person as you're walking down the street, because you're not required to have the ID in the first place. So I'm back to where I started. So if it's not on your person, they don't look and they just throw you out. Okay, so let me make sure I understand this from your point of view, Nana Squish. Let me make sure I understand what you're proposing. Just to make sure that you understand what you're proposing. You say if it's not on your person, they don't look and they just throw you out. So what you're saying is that every American citizen should be required at all times to have some sort of identification paper on them. And if they don't have that identification paper on them at all times, then the US government should be allowed to summarily deport them, presumably to any country the US government wants, because they didn't have their identity. That's what you want. You want a requirement that every US citizen has identification papers on them at all times. That's your proposal? Just to make sure that that's what you want. You want every US citizen to be required to have papers on them at all times. Is that what you're saying? Because if that's what you're saying, I think you're going to have I think you're going to have problems with that proposal, both from the left and the right. I'm not actually sure who's going to be more mad about this proposal. I'm not sure which side of the political aisle is going to be more pissed on this proposal, the left wing or the right wing. I'm actually not sure which side of the aisle is going to be more pissed. But you managed to make everyone angry, so that's nice. If you're in the US and a visa, you're required to have your passport on you at all times. That's probably not true. You're probably not required to have your passport on you at all times. I'd have to double check, but I doubt that that's true. And even if it is true, what about US citizens? What do we do about the US citizens? Because the US government might make a mistake. So even assuming that people here on a visa are required to have a passport on them at all times, which I don't think is the law, but even assuming it was, again, what do we do about US citizens in this example? Like the US government can never make a mistake? What are we doing? I like, by the way, how Nanish has dropped out of the chat because they understand their position is completely untenable. See, this is the Socratic method. By just asking questions, I have shown them that their proposal is completely untenable. Because the only thing they really have no choice here. They can only jump one of two ways. They either have to say no, U.S. citizens shouldn't be required to have papers on them all times. At which point I'm back to like, okay, then due process. Or they have to jump the other way and say yes, they should be able to have papers on them at all times. At which point I'm like, well, good luck with that plan, both with the left and right wing. So I put them into a corner where they have no escape, and they can't figure out what to do. Being undocumented is not a crime. Strictly speaking, that's true. Being undocumented is not a crime unto itself. That's true. Which is why calling people who are here illegally undocumented is bad, because it's misleading or not complete. Calling illegal immigrants undocumented is not accurate because that implies that a U.S. citizen is documented, which isn't necessarily true, except for perhaps a birth certificate, which is sitting in a file somewhere. Maybe, depending on where the person was born and when and how and so forth and so on. Right? You have to be able to produce your passport, not have it on all the time. Yeah, it wouldn't make sense that. Yeah, I'm like that is probably not true. It's probably not true that you have to have your passport on you at all times. That sounds wrong. Yeah, like if it's sitting in your hotel room, that's probably legally sufficient. If I had to guess, that you have to have it available in some sense, yes, but that you have to actually have it on your person, no, that sounds wrong. Yeah. Yeah, it's not mandated, but recommended to have a copy. Yeah. And it's like, yeah, it's not required. Yeah. Yeah. It's like, yeah. I got denied a Connecticut license because the perforation on my birth certificate was not up to DMV standards. That's funny. Probably have more green usernames in chat if I talk to them a little bit more pleasantly and not like I'm the smartest person that ever lived. I'll try to keep a note of that. Thank you. I don't think I'm the smartest person that ever lived. I definitely make mistakes. But then, like, by questioning this guy, because I'm like, have you really thought this all the way through? It's like, have you actually thought this through? And it's like, no, you haven't, because you wind up in a place that doesn't work real fast. But I make mistakes all the time. I don't know things all the time. Like, for example, I'm still not 100% sure on that confrontation clause issue in the coronary case. I still don't know for sure. Yeah, so even on legal stuff, sometimes I get stumped. And then, of course, the Supreme Court, like, I usually get stumped once or twice a year on something because there's usually, like, really conflicting principles. I don't know what to do. I'm definitely not the smartest person that ever lived. I do okay for myself, but, I have a lot to do. My tone is very off-putting. I don't know what to do about that. It's like, let me ask you some questions about what you think. I mean, to be fair, I did think his point was somewhat absurd. So if I responded to it with a tone that implied absurdity, then that was an accurate reflection of what I was feeling. Because I'm like, this is absurd. You have not thought this through. Smith versus Arizona regarding the Karen Reed case. That's not a bad idea. Let's take another look at it. It's been a while. Let's take another look at it and see if it informs our situation. Let's do it. Let's see. Is that a confrontation clause? Smith v. Arizona, not versus United States. Let's take a look. 2024. Yeah, so basically some new law. Yeah, Supreme Court case I did. I was totally lost at the end. Yeah, that happens too. Yeah. I sometimes, everyone, I like to think I'm a pretty reasonably intelligent guy, but sometimes when I'm reading a case, especially before the case is decided, but I think you're right. Even in that case, even after it was decided, I think I was confused initially. I seem to remember having to reread it or something to try to understand what they were talking about. But yeah, every once in a while I get confused on some. Yeah, I need help. And sometimes I need a second opinion. Yeah. Let's take a look at this case, Smith versus United States. See how much it informs the situation that we're in. Let's see. Okay. Sixth Amendment guarantees. Let's read the syllabus. I'll read the syllabus, and then if I need to, I can read more. The Sixth Amendment Confrontation Clause guarantees a criminal defendant the right to confront the witnesses against him. In operation, the clause protects the defendant's right of cross-examination by limiting the prosecution's ability to introduce statements made by people not in the courtroom. The clause thus bars the admission at trial of an absent witness statement unless the witness is unavailable and defendant had a prior chance to cross-examine. The prohibition applies only to testimonial hearsay. And the two-word phrase in that phrase are two limits. First, in speaking about witnesses or those who bear testimony, the clause confines itself to testimonial statements, a category this court has variously described. Second, the clause bars only the introduction of hearsay, meaning out-of-court statements offered for the truth of the matter asserted. Relevant here, the Confrontation Clause applies in full to forensic evidence. For example, in Melendez-Diaz versus Massachusetts, prosecutors introduced a certificate of analysis stating that lab tests had identified a substance seized from the defendant as cocaine. The court held the defendant had the right to cross-examine the lab analysis. In Bullcoming versus New Mexico, the court relied on Melendez-Diaz, told that the state could not introduce one lab witness's written findings through a testimony of a substitute analysis. So you need like the person who actually did the lab test themselves. Finally, in Williams versus Illinois, the court considered a case where one lab analyst related an absent analyst's findings on the way to stating their own conclusion. This sounds like a little bit more like on point for our current situation. The state court held the testimony did not implicate the Confrontation Clause because the absent analyst statements were not introduced for the truth, but rather to explain the basis. 5 members of the court rejected that reasoning. But because one of the 5 affirmed the state court alternative grounds, Williams lost. So Williams versus Illinois might actually be the better case for this situation. So we might have to take a look at that case, but that might be the better case because that sounds more on point than what we're reading. The case presents the same question which the court fractured in Williams. Okay, so maybe this is just Williams part 2. So maybe we don't need to read Williams. So this is just Williams redo. Arizona law enforcement officers found petitioner Jason Smith with large quantity of what appeared to be drugs and drug-related items. Smith was charged with various drug offenses and state sent the items to the crab lab for scientific analysis. Analysis Elizabeth Rast ran forensic tests on the items and concluded they contained usable quantities of methamphetamine, marijuana, and cannabis. Rast prepared a series of type notes and a signed report about the testing. The state originally planned for Rast to testify about those matters at Smith's trial, but Rast stopped working at the lab prior to the trial. So the state substituted another analyst, Gregory Lagoni, to provide independent opinion of the drug testing performed by Rast. At trial, Lagoni conveyed to the jury what Rast's records revealed about the testing before offering his independent opinion of each item's identity. Smith was convicted. On appeal, he argued the state's use of a substitute expert to convey the substance of Rast's materials violated the Confrontation Clause. The Arizona Court of Appeals rejected the challenge, holding that Lagoni could constitutionally present his own expert opinions based on the review of Rast's work because her statements were used only to show the basis of his opinion, not for the truth. Held, when an expert conveys an absent analyst's statements in support of their own opinion, and the statements provide support only if true, the statements come in for their truth. That sounds a lot like our current situation. Smith versus Arizona. That sounds a lot like our current situation. The parties agree that Smith's confrontation claim can succeed only if Rast's statements came into evidence for their truth. Smith argues the condition is satisfied here because statements were conveyed via Lagoni's testimony to establish that what she said in the lab did in fact happen. State contends that Rast's statements came into evidence not for the truth, but to show the basis of Lagoni's independent opinion. It emphasized the Arizona rules of evidence authorize the admission of such statements for that purpose. Evidentiary rules, however, do not control inquiry into whether such statements is admitted for its truth. Instead, the courts must conduct an independent analysis of the question. Truth is everything when it comes to the kind of basis testimony presented here. If an expert conveys an out-of-court statement in support of their own opinion, and the statement supports that opinion only if true, the statement has been made for the truth of what it asserts. The truth of the basis testimony is what makes it useful to the state. That is what supplies the predicate for and thus gives values to the state expert opinion. And from the fact finder's perspective, the jury cannot decide whether the expert's opinion is credible without evaluating the truth of the factual statements on what it's based. But that is what raises Confrontation Clause problem. For defendants, no opportunity to challenge the veracity of the out-of-court assertion they're doing much of the work. Here, the statements come in for their truth, and no less because they were made to show the basis of Lagoni's expert. That sounds pretty on point. All of Lagoni's opinions were predicated on the truth, well, at least this one in this case, were predicated on the truth of Rast's factual statements. And the jury could credit those opinions because it too accepted the truth of what Rast reported about the lab work. So the state's basis evidence, more precisely, the truth on which the expert relied, propped up the whole case. Yet the maker of the statements was not in the courtroom and could not ask called questions. So there's a point of differentiation here, I suppose, about how critical the statements are in terms of remedy. But it is a violation. So in this situation, it's like the entire game. In Karen Reed, it's not the entire game. So what remedy for the violation is perhaps an issue, but that there's a violation seems on point. What remains is where the out-of-court statement Lagoni conveyed were testimonial. Testimony issue followed on the primary purpose of statement, in particular how it relates to future criminal proceeding. But that issue is not fit for resolution. The question presented in cert took it as a given. The out-of-court statements were testimonial, which these are testimonial. And the Arizona court did not decide the issue. Indeed, there may not remain a matter to decide, as Smith maintains the state's forfeit argument they're not testimonial. Testimonial issue, including the threshold forfeiture question, is thus considered by the state in the first instance. So I think this case is directly on point. This case is directly on point. And so then the only remaining question for my mind would be what remedy for the violation if she's convicted, right? I don't think it necessitated a mistrial in the first instance. I think if the judge had corrected the error, and hypothetically still could correct the error, so I think the judge still could correct the mistake, even now, if she realized that there was a mistake, she could still correct it, and that would probably be sufficient. But if she doesn't correct it, and Karen Reed is convicted, this case seems like it's directly on point, and therefore you would have to figure out what is the remedy at that point. Can you still do a harmless error analysis on it? Can you still do a harmless error analysis despite the constitutional violation? or is it structural? Interesting. Interesting. Blah, blah, blah. Let's see if it has any thoughts on this issue. Crawford. When was Crawford decided? 2004. Yeah, the law has been changing so much, like on this area in like the last 20 years. Crawford's only 20 years old. Melendez, 2009. The law's changed a lot recently on this issue. Blah, 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 blah. Blah, blah, blah. Uh-huh. Uh-huh. Mm-hmm. Mm-hmm. I don't know if it's going to say what remedy there is for this problem. Yeah, it doesn't look like it. It doesn't look like it says unto itself what the remedy for the problem is. So, yeah. So I think this case is. I think this case is on point. So I think therefore, yeah, I think Judge Bev was wrong. Very interesting stuff, though. Very, very interesting. So what is the remedy for it, though? Unclear. We could ask ChatGPT what makes something a structural error, because it's been a while since I've forgotten. Let's ask ChatGPT, because ChatGPT knows everything, and it can remind me. Is 04 mini better than 03, or is it like not as good? I have a hard time remembering like which version is best version. Let's try 04 mini, I guess. Affects the framework of the trial process. So intrinsically hard. Total denial of counsel, trial before a biased judge, lack of impartial jury, denial of self-representation, absence of public trial, erroneous reasonable doubt instruction. Yeah, probably is not structural. Weaver v. Mass. Oh, no, I don't think so. Yeah, this is not. No, this is not a good citation. Yeah, I don't think this citation is on point. I'm going to pass that one. Open courts is one, not allowing public during voir dire. Yeah, those make sense, but I don't think this is a structural error. So you can probably still do a harmless error analysis. And if you do a harmless error analysis, then she's toast. She's not going to win on that. I think. She never admits she's wrong. Yeah. Travis, we should talk at some point. I think I have your email or phone number. We should definitely talk at some point. Yeah. Yeah, well, at least my skim of Crawford. Well, no, I didn't read Crawford. Did Crawford speak to remedy? I mean, it's just hearsay evidence, right? So it can't possibly be a structural error, right? I mean, it's just a hearsay violation. So it can't possibly be. Well, it's a confrontation clause problem. Okay, back to what I was reading. They sent back to Washington to do an error analysis. Probably that makes sense. Travis, do you think I come off as unduly arrogant, or do you think I come off in my tone as a know-it-all? Do I come off as like a know-it-all, or do I have interpersonal skills that need help? Do I come off as unduly like smart ass, or is that just part of my charm? Perhaps I'm a bit of a prick, but then again, I'm a lawyer. Lol. A little smug when I'm dunking on someone. Yeah, that's true. Yeah, I mean, at least my speed read. I'm not seeing a remedy here, but it doesn't feel like it's structural, right? It just feels like a fuck up. All right. It just feels like a fuck up. It just made a wrong evidentiary ruling in a way that violated the Confrontation Clause, but like, it just feels like kind of it just feels like a fuck up, not like a structural problem. So I'm going to go with it's probably not structural. Yeah, I'm going to go with it's probably not structural, which means we're probably into a harmless error analysis if Karen Reed is convicted. That sounds right in my head. And it's pretty easy to like see how that gets written in a way that basically upholds the verdict for that reason. Basically that it's in the grand scheme, basically relatively inconsequential. It's like I can basically write the outline of that in my head for, it's an ancillary issue. It's an ancillary issue that isn't even in the core of the matter of the opinion, let alone the core of the underlying issue. It's ancillary issue, and there's so much other evidence that blah 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 something something something, hand wave away, we're going to uphold it for that reason. That sounds vaguely correct in my head. Not for the least of reasons, incidentally, that as we've recently discovered, as some of you may know, Judge Bev has been overruled a number of times by the Court of Appeals, but every single time, I think it's true, every single time she was overruled, it was because she decided something in favor of the defendant. So I guess she got the memo, right? After being whacked enough times by the Court of Appeals, apparently she got the memo. Stop being nice to the defendant. Start being an arm of the prosecution. Got it, boss. So that alone suggests to me that the Court of Appeals is not going to go out of its way to overrule Judge Bev having decided something in favor of the government. That is the real politique of the situation. The Court of Appeals doesn't give a fuck, so why would Judge Bev give a fuck? Plus, she was, recently honored in all those awards and stuff. Yeah, I don't have a lot of high hopes for an appeal. I don't have high hopes for an appeal. Not to say that there aren't grounds of appeal. There are more grounds of appeal than in a typical case, but I don't necessarily have I don't necessarily have high hopes for those appeals based on what seems to be the tenor of the Court of Appeals on these kinds of issues. Am I suggesting Bev is a victim rather than a perpetrator? I'm suggesting that having been whacked around by the Court of Appeals a number of times, she got the memo and understands the assignment. And now she's a good little foot soldier because she does what her masters want. So, Massachusetts courts generally file harmless error for constitutional errors. Yep, that sounds vaguely right. Travis. Harmless beyond a reasonable doubt. Yeah. Yeah, I'm sure they'll say no problem. Yeah, it's fine. It was ancillary. It's not really the core of that expert's opinion, let alone and there was so much other evidence, blah, 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 guilty. Yeah, no problem. I can write it in the back of my head. No problem. Yeah, it's easy. Easy peasy, man. Easy peasy. Bev is acting like he'll give her the max sentence. I assume that any sentence will be effectively life. What is the penalty in Massachusetts? Mass penalty, second degree murder. What is the penalty for second degree murder? Oh, it's just straight life. Oh, wait, no, hold on. Oh, yeah, it's just straight life and eligible for parole at term of year fixed by court pursuant to something. So it's life with parole. Oh, okay. Oh, well, that's easy. I mean, it's just life with parole, with a possibility of parole with a minimum of 15 years, depending on details. Yeah, let's just assume that she's in jail for the rest of her life. That's probably the right answer. That sounds like the right answer. How about for manslaughter? Let's see. An imprisonment for up to 20 years. Which I assume she'll get. Because dead cop, you know. So, and Karen Reed is, how old is Karen Reed? She's pretty, how old is Karen Reed? 45? So she's my age? Yeah, so she might get out when she's in her 60s. Exciting, something to look forward to. Texas is weird on it. Texas is the most bizarre one yet on this because it's 5 to 99 or life for murder. Who comes up with these numbers? Or is it 10? I think it's 5. Or is it 5 or is it 10? It's like 5 to 99 or life for murder in Texas. Like, who comes up with these numbers? Massachusetts is like life. Texas is like, how about 5 years? Oh, yeah. First degree murder is 5 to 99. Second degree murder, 2 to 20. Texas apparently is fairly lenient with the murder conviction. Who knew? Who knew Texas was so generous, right? Who knew Texas first degree murder, you could come out with a 5-year sentence. We apparently are not that serious about murder over here in Texas. You know, it has been said that they needed killing as a defense in Texas, and they aren't wrong, man. They needed killing apparently is a perfectly viable defense in Texas. Yeah, they just really needed killing. How about 5 years? Holy shit, man. This is a weird state sometimes, man. Oklahoma, too. You would think that Texas would be like super draconian. Apparently, we're giving people hall passes over here. What the hell? I might do the 5 years just for the accolade, just for the like. That's like, you know, it's like I get to say I'm a murderer. And it's like for 5 years, man. That's a good deal, man. I get to kill somebody. I only have to do 5 years in prison. That's not a bad deal, man. Depending on who I'm killing. Do I get to select who I get to kill in this scenario? Probably not. I probably don't get my choice. I have to find someone that people don't like very much. Five years, there's probably some in other states, there's like I think technically some misdemeanors in some states can get you up to 5 years. In some states. The usual delineation is 1 year for a felony, but I've definitely seen misdemeanors with higher penalties than 1 year. It wouldn't surprise me if there's a state out there with a misdemeanor with a 5-year penalty. And Texas over here, how about first degree murder, 5 years? That's great. We're the best. And then I think it's Maryland, where in Maryland still like their entire murder is still common law. They have what used to be called first degree murder on the statutes, but because when they used to have capital penalty, so they still have what's called first degree murder, or what used to be called first degree murder. It might still be called first degree murder. It's on the statutes, but every other version of murder is still common law. That is great. You got to love that, man. You got to love that. We didn't even bother to write down murder is illegal in our statutes. That's how hardcore we are over here. We didn't even bother to write. We have a legislature, but we just don't have time to write down murder is bad. What you gonna do, man? What you gonna do? Seriously? Yeah, pretty much. Actually, to be honest, in Massachusetts, it's kind of common law too, because we read the definition, right? Actually, in Massachusetts, it's also common law because we read the definition, right? Because it was like, yeah, it actually suffers from the same problem. So Massachusetts also, its entire murder is common law because the statute says first degree murder is with malice and blah, 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 right? It actually defines first degree murder. And then it says any other degree of murder that's not first degree is second degree. But it doesn't define what second degree, it doesn't define murder at any point in the statute. It defines first degree murder with the malice and the malice and the hardened heart and all that bullshit. It defines first degree murder with some actual elements. But in Massachusetts, they just say any other degree of murder other than first degree is second degree. So actually their entire murder statute is also common law. They also couldn't be bothered to write it down. Apparently the New England states don't believe in writing murder statutes. They don't believe in, they just cannot be bothered to write it down. It's fucking great. Yeah. Yeah. Yeah, it's unnecessary. I mean, there is a certain logic to it, I suppose, because murder is what's considered malum in se. It's bad. It's so bad we don't need to actually write it down. Or we don't need a law that tells you what it is because it's just inherently bad. So it's bad unto itself as opposed to malum prohibitum, right? It's bad because we passed a law saying it's bad. So it's so bad we actually don't need. It's just been defined already somewhere in the ether. Please don't kill people, I guess. And I'm willing to bet you, the only reason Massachusetts wrote down first-degree murder is because they had to in order to do the death penalty. That's probably the only reason they bothered to write it down in the first place. I'm willing to bet that was what it was. The only reason they bothered to write down first-degree murder in the first place was so that they could have a death penalty. And then, of course, they got rid of the death penalty, but the statute's still in the books. Yeah, that's what it is. That's 100% what it is. That is 100% what it is. They wrote it down so they could kill people, and then they stopped killing people. That's exactly what happened. Yeah. Yeah, that's what happened. That's great. I think the odds of conviction are about 40%. That's what I'm going with. I think the odds of conviction are 40%. The only thing that would change that at this point is the state's rebuttal case. If the state really has some dynamite rebuttal stuff, that those odds could go up. But because I already know what the defense case looks like, because we saw it the first time. So, we're not going to get. It doesn't look like we're getting any surprises out of the defense case. They're not calling Proctor. They're not calling Paul. They're not going to call anyone else that we wait to hear. They're not going to call Karen Reed. So, like, the defense's case is kind of a foregone conclusion at this point, because there's not really any surprises coming down the pipe, I don't think. And so the only thing that's possibly different is the state's rebuttal case. So if the state really can really knock something out of the park in its rebuttal case, those odds could go up a lot. The law books in your PD office are still wrapped in plastic? That's funny. I can't believe that 40% likely to convict. I believe it. I totally believe it. Otherwise, I wouldn't say it. The betting markets right now are predicting 26%. I think they're underestimating it. Do I want your argument as to why you think the percentages are different than me? Well, I mean, without hearing your argument, I'm implicitly, I assume implicitly that the reason you think it's different is because you're weighing how various factors are going to play into the equation differently. I assume. So if your argument is basically like, here are the elements and here's how I'm weighing them and weighing them differently, then I mean, I guess I understand that. But if it's something more fundamental than that, or something more systemic than that, then let me know. But if it's just like, I think you're wrong in terms of how you're weighing various factors, I mean, it's just a best judgment call. The premise. Okay, what you got? What you got, Ryan? Type faster. Hank is definitely doing better than Lally. Much, in my opinion. Yeah, 40% including the lesser included. So yeah, 40%, 40% on some version of first and second degree is the prediction. Yeah. So the 40% includes the lesser included. So what was your argument, Ryan? I'm sorry, I missed it. Did I miss something? Oh, you grant my argument? Oh, okay. Yeah, fair enough. Yeah, I think 40% to convict some version of first or second degree. Seems plausible. Travis, 40% plus and lesser included for me. I think they'll convict on the lesser included 2 to 5. Yeah. Did they come anywhere close to meeting their burden of proof legally? Yeah, on sufficiency of evidence, I think they're there. So it's definitely more so than last time. Yeah, there's enough for a legally sufficient verdict for guilt. The defense, it's basically any reasonable jury. So you have to like sort of in your mind sort of imagine the Overton window of like possibilities. So you don't necessarily have to like, go 0 to 100, but you have to imagine. I don't know what the Overton window is for a criminal case. Is it 10 to 90%, something like that? Probably something like that. It's pretty wide. It's not infinitely wide, but it's pretty wide. So you have to imagine. You have to imagine the jury is entitled. The jury is entitled to determine what testimony to give credit to, and then also determine the weight of that testimony. So you sort of have to, if you're doing sufficiency, what you kind of have to do in your mind is you have to say, is there any reasonable combination of evidence, which is to say, is there any reasonable combination by which jurors can believe certain evidence and not as they're making that decision? So like you have to sort of remember that the jury has the right to disbelieve evidence completely because they do. Because they can find it not credible or the person lying or whatever, let alone weight it. So you have to sort of say, is there any reasonable way for a person to credit certain testimony or not, weigh certain testimony or not, and do so in a way that would get to beyond a reasonable doubt? So having decided what evidence to count at all, because they don't have to consider all evidence because they can discount it or weigh it to 0, basically. Having decided which evidence to count, can they then get to beyond a reasonable doubt? In a legal sense, yeah, they're there. They're there. There's legal sufficiency. That isn't to say they convinced me. It's to say that as a hypothetical court of appeals judge on sufficiency of the evidence, now on that first trial, On that first trial, I think you could have made the case. But on the second trial, as a Court of Appeals judge, I don't know, ma'am. I don't know. Not without really like usurping my role as a Court of Appeals judge, because my judge isn't like to read. My job isn't to decide what I would do, but to decide what a reasonable jury can do, and they're allowed a lot of latitude. So legal sufficiency is there. In other words, would the jury have to be batshit insane? If you want to simplify this, would the jury have to be batshit insane to say guilty? And I don't think the answer to that question is yes. Unfortunately, I think they can get there without batshit insanity. So that's annoying. All right. Well, I guess I'm going to go ahead and sign off. I've had fun. I hope you've had fun too. We will see you, if not tomorrow, then the day after. Really, how? Use your imagination, Naomi. I mean, you have to it's difficult because you have to sort of put yourself outside of yourself and remember how other people think about things. So do you have the ability to think like other people think, or imagine how other people think? I mean, it's difficult, but you have to remember that reasonable people think a lot of different things. So, yeah. All right, I'm going to sign off for now.